Good evening, ladies and gentlemen. For the past 29 years, Hindus were prevented of their basic right for offering puja at the Ma Shingar Gauri temple, or rather Ma Shingar Gauri inside the Gyanvapi complex, except for one day in the entire year. And today, the district judge in Varanasi has opened a door to correct historic religious wrongs, or so say the petitioners. A move that many say will go down in the history as the first step towards restoring of Hindu Astha. The court today declared that Places of Worship Act cannot apply to the Gyanvapi suit. This was the main argument that the Muslim side was banking on. The city of Varanasi resonated with chants of Har Har Mahadev. As soon as the verdict came, the scene outside the court was jubilant. The devotees and petitioners claimed that the Lord Almighty has answered their prayers. Listen in.
आज हम सभी हिंदू भाई और पूरे सनातन धर्म को अपने हाथ जोड़ के अपने हिंदू भाई से कहना चाहते हैं कि आज बहुत बड़ी खुशी का दिन है। आज हम चाहते हैं कि सभी लोग अपने छत पे घी का दीपक, शंख, नगाड़े बजाएं। आज हम लोग की बहुत बड़ी जीत हुई है। आज हम लोगों ने चारों लोगों ने इतिहास को रच दिया है। आज बहुत अब हम लोग का बाबा का दर्शन और माँ सिंगार गौरी का पूजा पाठ सुनने।
हमारे हिंदू धर्म के पक्ष में ये फैसला है और हम अब वहाँ पर शिव जी और पार्वती माता की पूजा कर पाएंगे और शिवलिंग की ऊपर जल चढ़ा सकेंगे। सब
बहुत खुश है जी, हमारे हिंदू धर्म के लिए, खासकर हमारे जिन्होंने हमारा ये सारा सृष्टि रची है भगवान ने, शिव जी ने। आज उनके जहाँ जिस चीज़ का किसी को पता ही नहीं था, आज वो भी सब कुछ सामने उठ के आया है।
While worshipping and offering prayers may be still some way away, as the matter is only been allowed to be heard, and that the Places of Worship Act cannot come in the interim, all the arguments of the Masjid panel were dismissed on this issue as the court ruled that the Hindu petitioners don't want ownership but just the right to worship, which exempts them from coming under the ambit of the 1991 law. Refusing to budge, the Muslim side is all set to challenge the verdict in the High Court. Listen in.
कोर्ट ने मुस्लिम पक्ष को अपना जवाब दाखिल करने के लिए कहा है और 22/9 में इसकी अगली तारीख लगाई गई है। इस जजमेंट के बहुत बड़े मायने हैं, क्योंकि जो हमारी कमीशन की रिपोर्ट है अब वो पढ़ी जाएगी, उसके खिलाफ उनको ऑब्जेक्शन देना पड़ेगा और जो कमीशन की रिपोर्ट में शिवलिंग बरामद हुआ है अब उसमें आगे बात होगी। ये सारी महिला याचिकाकर्ताओं के लिए बहुत बड़ी जीत है।
हम लोग आगे इसकी अपील करेंगे, क्योंकि ये आर्डर हमारे लीगल हिसाब से भी सही नहीं। हाई कोर्ट करेंगे, हाई कोर्ट जाएंगे। तो अब ये जो 22 होगी उसके पहले हम जेल में हाई कोर्ट जाएंगे। सुनवाई शुरू होती है तो उसमें अगला यहाँ पर क्या स्टेप होगा? यहाँ पर कोई, वहाँ हाई कोर्ट में जो होगा हाई कोर्ट से आर्डर होगा, वहाँ के आर्डर होने के बाद यहाँ कोई होगा, देखा जाएगा।
While today's decision by the court has given hope to the Hindu side that the day is not far when the court will take note of the shivling and traces of the Hindu temple found inside the complex of the Gyanvapi, irrefutable evidence featured in the 10-hour-long videographic survey. But that's a belief. From shivling inside the Wazukhana to Trishul markings on the mosque wall to lotus motif and inscriptions in Sanskrit, all of which will now be brought to the notice of the court. But there is no end to the fear-mongering of people like Asaduddin Owaisi, who are already warning of a destabilizing effect. They maintain that the ripple effect of this judgment today will be similar to that of the Babri Masjid demolition. The BJP and the Saffron leaders insist that today's order will lay the foundation for unshackling the Krishna Janmabhoomi in Mathura as well. Listen in to this war of words.
आज के ऑर्डर के बाद ऐसा लगता है कि फिर अब ये लिटिगेशन शुरू हो जाएगा इन तमाम इश्यूज के ऊपर और हम दोबारा 80 और 90 के दहे में वापस जा रहे हैं। फिर तो ये हर जगह पर एक डिस्टेबलाइजिंग इफेक्ट पैदा हो जाएगा। तो ये हम तो उम्मीद कर रहे थे कि कोर्ट इस तरह के इश्यूज को जैसे अंग्रेजी में कहते हैं कि दे विल निप इट इन इट्स बड। मगर अब लगता है कि इस तरह का लिटिगेशन अगर आगे बढ़ेगा तो फिर ये उसी रास्ते पर जा रहा है जो बाबरी मस्जिद का लीगल इशू गया था।
अयोध्या, मथुरा, काशी 3 ऐसे स्थान हैं जो हिंदुओं के लिए वेटिकन सिटी और मक्का मदीना के जैसे हैं। काशी विश्वनाथ जी का स्थान है, अयोध्या राम जी का स्थान है और मथुरा भगवान श्री कृष्ण का है। और ये तीनों ही हमारे पूज्य देवता हैं। अगर इन तीनों को आप इनसे अलग कर देंगे तो आगे ये देश बहुत शांति से रहेगा, क्योंकि यहाँ पर जो आक्रांताओं की यादें बनी हैं वो हमें बहुत अपमानित करती हैं, हमारी बहुत बेइज्जती करती हैं और करोड़ों लोग यहाँ जाते हैं। मैंने ये कहा था उस समय, आज नहीं, आज परिस्थितियां बदल चुकी हैं। मैंने कहा था कि अगर अयोध्या, मथुरा और काशी ये तीनों स्थानों पर आपस की सहमति से भव्य मंदिरों का निर्माण हो जाएगा तो हिंदू इतना बड़ा दिल रखने वाला समुदाय है कि वो बाकी मस्जिदों पर संकट आता देखेगा तो खुद डंडा लेके खड़ा हो जाएगा।
So the legitimate question we are asking on the Newshour tonight: why discredit legal respite to Hindu Astha? That's the question and that's the debate. Hindus get justice. That's the hashtag and the debate on the other side.
You're watching the News Hour at night. Debate number 1 on Times Now. Super Prime Time.
Joining me tonight, Professor Atiqur Rehman, political analyst, Pawan Rao Ambedkar, national spokesperson of the AIMIM, Tehseen Poonawala, political analyst. Joining me in the studios tonight, Vinod Bansal, national spokesperson of the Vishwa Hindu Parishad, Dr. Anand Ranganathan, author. But my first question goes to Vishnu Jain, joining us live from Varanasi, lawyer for the petitioners, the man who has the victory under his belt and celebrations around him. Vishnu Jain, many people today are asking you the question on whether this is now the beginning of opening up of a destabilizing impact, as Mr. Asaduddin Owaisi calls it, across the country by reopening cases in various parts of the country.
See, Navika, very good evening. And I would like to say that we as lawyers, our task is that whatever legal research we do, and if in a given set of facts we find that in certain place there was a pre-existing temple which has been demolished and converted into a mosque, then therefore we have all the legal rights to approach the court and unwind it and therefore continue the battle so far as those aspects are concerned. Now my point in issue is this, and till today no Muslim scholar has answered this, including Mr. Atiqur Rehman and others, that can you ever say that you can make a mosque after demolishing a Hindu temple? In Deen Muhammad's judgment in this very case, the Honorable Judge has recorded a finding that it is not correct, and as per Islamic law also, that if you demolish a Hindu temple, you can never create a valid mosque. And therefore we are doing these litigations, and I am not a leader of any political party. I will not go on to make any bold statements that yes, it's open door for all the mosques in the country. Wherever professionally we are working, our legal team is working very professionally and clinically. Wherever we will find all the documents and research and papers and that there was a pre-existing temple which has been demolished and still the facts of the matter show that the remains of the temple exist. In all those cases, if the documents come to our legal team, we will definitely file cases. But today, as a lawyer who is practicing and who is doing all such matters, I cannot make any bold statement because my role as a lawyer is very limited and we work professionally. We don't have any political gains in the matter. It's all a legal perspective which is going into the matter.
Fair point, Vishnu Jain. Atiqur Rehman, a valid question raised by Vishnu Jain. सवाल पूछा है, जवाब दीजिए. Can there be a masjid that can be erected on a demolished mandir site? That's the question.
As always, Navika ji, I have answered him so many times, but he never listens to me. There cannot be any namaz on a place wherein the land has been captured. But what about when the Supreme Court said that in the Ayodhya matter there was no temple demolished at that Babri Masjid site which you demolished, and can you now offer prayers there?
Sir,
anyway,
we are talking about Kashi's case.
The past is past. Navika ji, I want to pinpoint. Please don't disturb Mr. Jain. Mr. Jain, your research today establishes that there were so many atrocities on the Hindu temples. You know, where will you end this? You want to put the Indian people in perpetual enmity by your research? You do not oblige by the parliament of the democracy, the temple of democracy, which is parliament, which has passed an act 1991, places of worship. You do not endorse it. Your research is putting the entire Indian people into perpetual enmity. That is acceptable to you? Which Hindu and which Muslim will be going in a temple and a mosque praying with the heart of...
Vishnu Jain is responding to you. Vishnu Jain is responding to you. Vishnu Jain.
Navika ji, with lot of sense of responsibility, today on your channel I want to ask a question to Mr. Atiqur Rehman. Can in वजू you will have शिवलिंग, और शिवलिंग में आप वजू करते रहेंगे और सुप्रीम कोर्ट में कहेंगे कि हमें वजू वहीं करने दिया जाए, और जब मैं सामने निकल के आऊंगा और कहूंगा कि वहां पे शिवलिंग पे वजू नहीं हो सकता है, तो वो एनिमिटी प्रमोट करेगा? आप मेरे शिवलिंग पे वजू करते रहें, उससे एनिमिटी नहीं होगी. यू आर नॉट कमिंग ऑन चैनल एंड सेइंग अतिकुर रहमान कि उस शिवलिंग की जांच होनी चाहिए, कार्बन डेटिंग होनी चाहिए, पता चलना चाहिए कि शिवलिंग है कि फाउंटेन है. आई एम तो टिल टुडे सेइंग ऑन टाइम्स नाउ नेशनल न्यूज चैनल दैट इज शिवलिंग की जांच हो कि ये शिवलिंग है कि फव्वारा है. पर आप लोग क्या चाहते हैं नाविका जी? व्हाट डू दे वांट? दे वांट कि अगर इन्होंने कह दिया फाउंटेन है तो वहीं पे एंड ऑफ द स्टोरी हो जाए, आगे कोई इन्वेस्टिगेशन ना हो, कोई बात ही ना हो. और ये डेमोक्रेसी की बात करते हैं, इनकी सारी बातें सेल्फ कंट्राडिक्टरी हैं. और ही इज सेइंग दैट आई वांट माय रिसर्च इज क्रिएटिंग एनिमिटी.
So far, this is a disputed symbol that has been found. Some people call it a fountain, some people call it a shivling. It hasn't been decided. All that the court has said today is that at least the plea can be heard. You are saying that if they have a point of view that should not be heard, and only their point of view creates enmity. Your point of view does not create enmity. That's the question Vishnu Jain is putting to you. Respond to that question.
Navika ji, this particular matter of the shivling has created enormous amount of heat and jealousy amongst the people of India, both communities. And I would restrict myself only by quoting one Quranic verse, that is, do not revile the other faiths, lest in return they revile your gods. Why should we do it? A shivling is very much, this thing, a state of honor for the Muslims, equally as the wuzu khana should be in respect of the other faiths.
Of course.
We are not discussing religion here. We are discussing the law of India.
Declares in its judgment in the hearing that is now being allowed to go further. If they say that this is a fountain, then my friend, it will be a fountain. Nobody can contest it, other than inside a higher court. You cannot contest it outside the court. You will have to contest the matter in a court of law. So, Tehseen Poonawala, right now, nothing has happened either to decide whether it's a shivling or it is a fountain. That matter will be heard. The fact of the matter is, even before that has begun to happen, that hearing has begun at all, there is this whole charge that is being made that, even asking a question is creating enmity. How valid is that?
Good evening, Navika ji. Good evening to all my fellow panelists, your viewers, and at the onset, congratulations to Vishnu Jain bhai. On the first step, he's got success. Of course, this will be challenged on the higher courts, and that's the constitutional framework. But Vishnu Jain ji said something very interesting on your show, and he said, look, my research indicates everywhere where there is or used to be a temple, as per his research, they will go about it legally. But that is precisely contradictory to the POW Act, the Places of Worship Act 1991. But before I come to that, Vishnu Jain bhai, this particular suite was only a maintainability suite. So why are you going about saying that this is the first step towards reclaiming the temple, when this was only a maintainability suite and nothing has been agreed out there? Now for the second part of the question, which the learned panelists rightly said, if you are going to go against the Places of Worship Act 1991, where does this stop? 700 years? 1,000 years, 18th century, 17th century, 15th century, 10th century. What if tomorrow, for example, a Jain community says, look, we had a temple here which has been demolished and another religious structure has come out. Or a Buddhist monastery says it was demolished and now another religious structure has come out. Or a mosque says we had a mosque here originally which is demolished, say in the 5th century, and now something else has come here. Where do we end? Therefore, Parliament in its wisdom considered 15th August 1947. I know the BJP doesn't like the date because they were not involved in independence struggle when India became a constitutional democracy. Are we now going to let go of our constitution only to go back into the past history of who did what, and where does it end, Vishnu bhai?
But that's exactly what the court has said today, that this has nothing to do with the 1947 position, because till 1993 prayers were offered there till 1993, which is after the passage of the Places of Worship Act. But Vishnu Jain, respond to the question by Tehseen Poonawala. Before I get you, Anand.
See, Navika ji, the point is that Places of Worship Act itself is unconstitutional, and the Supreme Court will hear that matter on 11th of October. A 3-judge bench will hear it. Now, through our legal research and interpretation, we have tried to convince the Honorable Court that even the Places of Worship Act is considered as it is. The word which is used in the Places of Worship Act, and I would draw the attention of Mr. Tehseen Poonawala, my brother, on those two words. Religious character has to be determined as existing on 15th August 1947. It can't happen that there will be a शिवलिंग in the property in question. संस्कृत के श्लोक लिखे होंगे, नीचे देवी देवताओं की खंडित मूर्तियां होंगी, हिंदू देवी देवताओं के पिलर होंगे, और उसके बाद आप उसमें नमाज पढ़ेंगे और उसका धार्मिक स्वरूप बदल जाएगा. Mr. Tehseen Poonawala is a very well-read man, and I know he would have heard the discussion of the Honorable Supreme Court when the Anjuman Intizamiya came in the Supreme Court, and the Supreme Court observed that धार्मिक स्वरूप तय होना जरूरी है, और अग्यारी और क्रॉस का एग्जाम्पल दिया गया था. तो यहाँ पे यही एक्सरसाइज की जा रही है कि इस मंदिर और इस मस्जिद का धार्मिक स्वरूप क्या था, और जो हमने क्लेम किया है कि इन ऑब्जेक्ट्स ऑफ वर्शिप उस तथाकथित मस्जिद के अंदर हैं, वो ऑब्जेक्ट्स ऑफ वर्शिप एग्जिस्ट करते हैं कि नहीं करते हैं, ये सिर्फ पूजा के अधिकार की याचिका है. तो मुझे लगता है इट्स नॉट द क्वेश्चन कि हाउ फार बैक विल गो इन हिस्ट्री. द कट ऑफ डेट ऑफ 15th August 1947 itself is unconstitutional, because 15th August 1947 we just got our independence. If there has to be a cut off date, I want to say on your channel, it has to be 1192 when the last Hindu Raja was existing in question. And if Mr. Poonawala has so much pain for the Jain community, he is also a lawyer. He should file some cases where the Jain community temple has been destroyed and some religious faith has taken it over.
No, Vishnu, why is 1192 an arbitrary date?
I'm also fighting.
Why not 780? Why
so
not
the
580?
point is, Navika ji.
So till 1192.
So let's. Yes. I'm saying let's agree.
Just because you decide,
Tehseen bhai,
Vishnu bhai, your arbitrary date cannot be over the wisdom of Parliament in
Just because you decide, it can't be a final date.
It's Parliament of India, sir, that is decided.
If Parliament is having so much of wisdom, then why do you challenge CA? Citizenship amendment
that has also been passed by. Yeah, that is the problem. 1 minute, that is the problem. They will not. You know, Tehseen Poonawala is a petitioner in the CAA case, which has also been passed by the Parliament, and he's challenging it in a court of law. In a court of law. So Anand Ranganathan, this is a phrase that has been often used by the opposition, brute majority. So brute majority doesn't suit them after 2014, but brute majority in 1991 or 2004 to 2014 is a convenient brute majority, and that should not be questioned. I want to ask you, Anand Ranganathan, why is Mr. Asaduddin Owaisi already reading the Riot Act to everybody saying, oh, Babri Masjid ho gayi? It's only an allowance that this matter of offering, Gauri Shingar Puja, that can be heard. अभी तो उस पे भी फैसला नहीं हुआ, अभी तो ओनली हियरिंग पे फैसला हुआ है और इतना खलबली मच गई है. Why are they so worried?
Good evening, Navika, and good evening to all my fellow panelists. Navika, Mr. Owaisi is not reading the Riot Act, he's reading the scriptures. Bhai sab likha hua hai. Or it was very interesting, it's a wonderful debate, and very interesting to see the perspective of two minorities vis-a-vis the majority Hindus. One minority Mr. Jain and the other minority Mr. Rehman. बहरहाल नाविका, आप ये समझ लीजिए कि एक भी इंच नहीं दिया जाएगा हिंदुओं को, एक भी इंच. ये आग का दरिया है, इसमें डूब के जाना पड़ेगा. So kudos to Mr. Jain. But let me tell you also this, Navika, you can airbrush history. You can. People have. But you cannot airbrush a civilization. The court must be thanked for declaring that the plea is maintainable. And the Hindus must be thanked for pleading before the court to seek justice. If the holiest shrine of some other religion was demolished by a Hindu king and people of other faiths washed their dirty feet all around the sacred relic, this country would have witnessed a civil war. This atheist owes a debt of gratitude to 1 billion Hindus who are writing their history with the grammar of justice, not anarchy. Especially because it is beyond any doubt that Aurangzeb ordered the demolition of the Kashi Vishwanath temple and ordered that the Gyanvapi mosque be built over it. Only those who have read their history from the Romila Thapar WhatsApp University believe otherwise. It is written in most authentic biography of Aurangzeb, Masir-e Alamgiri, that in 1669 on the orders of Aurangzeb, the Kashi Vishwanath temple was demolished, and then 1 year later, he ordered the demolition of the temple of Mathura and had the idols brought to Agra to be scattered under the steps of the Begum Sahab mosque so that they would be trodden on. ऐसे हैं ये लोग, एक एक इंच के लिए लड़ना पड़ेगा. The Farman is also archived in Bikaner Archives, Navika, and here is Sir Jadunath Sarkar's translation of Masir-e Alamgiri, page 52, quote, Aurangzeb, eager to establish Islam, issued orders to the governors of all the provinces to demolish the schools and temples of the infidels and with the utmost urgency put down the teachings and the public practice of the religion of the misbelievers, unquote. And yet, there are those who deny the Hindus their legitimate right to correct historical injustice, and principal among them are our legislature and the judiciary. To me, Navika, one of the most barbaric legislations ever elected in India is the 1991 Place of Worship Act. But in 2019, the virtual signaling Supreme Court in its Ayodhya judgment willfully ratified this act that obligates maintaining all religious places as they were on August 15, 1947. Historical injustice, Navika, of Kashi can now never be addressed unless Parliament overrides it. A legal recourse to correct historical injustice cannot be denied in a democracy. And this is not a Hindu issue. I, a Darwinian atheist, demand the abrogation of the Place of Worship Act. Navika, just 30 seconds. If a mosque had been demolished by a Hindu king and a temple built on it, I, a kafir and an atheist for whom Islam sanctions death penalty, would have fought with my Muslim brothers for the right of Muslims to legally take back their mosque. If an image could speak 1,000,000 words, it would be that of the Nandi, waiting patiently for 400 years for his Lord to emerge and this historical injustice to be corrected. The Supreme Court said the Places of Worship Act speaks to our history and to the future of the nation. Wrong. This law airbrushes our history and destroys our future.
Well, I want to ask Mr. Pavan Rao Ambedkar. Mr. Pavan Rao Ambedkar, you know, there is a wrong that, the Hindus feel was done with their temple, and they have gone to court for the correction of that state because they have a certain faith and a belief. They haven't gone right now there to decide the entire issue by themselves. They've gone to court. Initially, what happened there? When they went to court and the court ordered a survey, the survey was challenged. The survey was challenged right up to the Supreme Court. The Supreme Court allowed the matter, to be surveyed and decisions to be taken at a later date, but at least the survey should go on. Now today, the judge who has heard this was given this matter by the Supreme Court himself. He heard this and he says, well, hearing is okay. The 1991 Act probably does not come in the way of the hearing, and therefore the matter can continue to be heard. Whether they finally get the right to pray there or not is still sub judice. My question is, why is it today itself that Mr. Owaisi begins to feel that now this is going to open a Pandora's box, this is the beginning of instability in this country, this is the beginning of some sort of a difference? The matter is in court. The court will decide. Do you not have faith on the courts of the land?
Thank you, Madam Navika. I just want to tell you, this country will run by the Constitution of India, not by faith. Faith is a negative word which is destroying this country's sentiments. This is the side effect of this order that Mr. Ranganathan is telling the historic statement. This country, I want to tell you, run by the rule of law, not by the faith. I just want to quote the one statement given by the Supreme Court in 2019's decision. The Supreme Court, while delivering the judgment on Ayodhya issue, said regarding the Places of Worship Act 1991, what the court said. The court said in 2019. Listen. Yes, I just want to talk on the.
Sir, you took my name. Did I take your name? No. I didn't take your name. Why have you taken my name?
This is the side effect.
2 minutes है. आप अपना point रखिए ना.
Side effect. Yes,
आप अपना point रखिए.
I'm going to tell you.
Why this futile exercise to get after me? You will only be humiliated and embarrassed. Don't do that.
This is the side effect. This is the side effect.
मेरे पीछे बहुत लोग आए हैं. Please don't embarrass yourself. You have 2 minutes. You keep your.
I'm not embarrassed.
Please come in.
I'm not embarrassed.
Please come in and ask this gentleman to make his point without making any reference.
You are so much enthusiastic person. You are so much enthusiastic person.
Being enthusiastic is not against the law. So far, the Constitution does not disallow any citizen of India from being enthusiastic. You make your point. You make your point, Mr. Ambedkar.
Make your point and carry on. Up the fiber.
Listen. In 2019, the Supreme Court of India tells regarding the Places of Worship Act 1991 law as an assurance against the same methods being used elsewhere regarding what? Future point of view. Supreme Court ko apprehension hai, आशंका hai. That's why regarding the 1991 Act is telling, and the one quotation is more, which is very prominent and which is very important. The Supreme Court said, the Supreme Court, listen, the Supreme Court said, this August 1947 is crucial because on that date we are supposed to have emerged as a modern, democratic and sovereign state, thrusting back such barbarity into the past once and for all. That's why we are talking about the constitutional law.
Well, it is the same Supreme Court. It is the same Supreme Court which allowed the survey to go on, but Anand Ranganathan respond to Mr. Ambedkar.
And just because Mr. Ambedkar, with due respect, I did not interrupt him. He took my name, so I have 2 questions to ask him. Very simple questions they are.
You are continuously interrupting me. Why are you not listening?
Navika.
Well, you took his name, so he has a right to respond.
That's why I'm telling this is the side effect of this order. Every person is very enthusiastic that I got this.
आप ओवैसी साहब के साइड इफेक्ट पे कुछ नहीं बता रहे, आप आनंद रंगनाथन के साइड इफेक्ट पर बता रहे हैं. आप ओवैसी साहब का जो साइड इफेक्ट हुआ है उस पर भी बता दीजिए.
वो साइड इफेक्ट नहीं, वो सच्चाई है. ये देश इस देश के भारतीय संविधान से चलेगा. आप लोग आस्थाओं के आधार पर क्यों चलाना चाहते हैं? मैं एक बार फिर से कहना चाहता हूं.
डॉक्टर रंगनाथन रिस्पॉन्ड टू मिस्टर अम्बेडकर.
इनको लीगली से कोई लेना देना नहीं है, इसलिए मैं इनको नॉन लीगली 2 एकदम आसान से सवाल पूछता हूं.
सर लीगली सुन लीजिए.
अब हु इज इंटरप्टिंग मिस्टर अम्बेडकर? You made your point. Anand Ranganathan is responding to you. I will come back to you, my friend. Just hold on. Little patience. Yes.
हाँ, इसमें नाविका, I know both of us are Punjabi, but इसमें मैं आपको भी दोषी ठहराता हूँ क्योंकि उससे पहले
मैं तो दोषी हूँ, गुनाहगार हूँ.
अच्छा, आप मिस्टर अतीकुर रहमान को भी आपने खुली छूट दी, उन्होंने झूठ बोल दिया अयोध्या जजमेंट का, तो अब उसका भी मुझे रिबट करना पड़ेगा. इतना टाइम नहीं है हमारे पास, तो आपको सिर्फ कहना चाहिए कि भाई झूठ मत बोलो, आगे बढ़ो. He said that Supreme Court did not say that the temple found underneath the Babri mosque was of Hindu origin. Completely wrong. Supreme Court said it and I can quote the judgment. But बहरहाल मैं मिस्टर अम्बेडकर पे आना चाहता हूं. यहाँ पे 2 सवाल हैं इनसे, एकदम सिंपल से. मिस्टर अम्बेडकर, क्या चर्चेज और मॉस्क्स गवर्नमेंट कंट्रोल के होने चाहिए, अंडर होने चाहिए कि नहीं, हाँ या ना? और नंबर 2, अगर किसी हिंदू किंग ने किसी मॉस्क का इस्लामिक रिलीजियस प्लेस ऑफ वर्शिप को डिस्ट्रॉय किया, उसके ऊपर मंदिर बनाया और मुस्लिम्स ने कहा कि नहीं, हमें ये मॉस्क या रिलीजियस प्लेस ऑफ वर्शिप वापस चाहिए, वो सुप्रीम कोर्ट के पास गए या जज के पास गए जस्टिस मांगने लीगली, क्या आप उनके साथ खड़े रहेंगे कि नहीं? हाँ, नाम है, सिंपल लैंग्वेज में आपसे सवाल पूछ रहा हूं, कॉम्प्लिकेटेड कुछ नहीं है, ये साइंस और मैथ्स नहीं है।
Okay, let Mr. Ambedkar respond and I'm coming to you.
सिंपल, अगर आप ये हिस्टोरिकली पॉइंट ऑफ खोद रहे हैं तो आपको बुद्धिज्म खोदना पड़ेगा, आपको मंदिर को भी चेक करना पड़ेगा, उसकी कार्बन
बोलेंगे
आते हैं, उसकी कार्बन डेटिंग कराइए, उसके कार्बन डेटिंग कराइए, यू विल गेट द हिस्टोरिकल पॉइंट। व्हाई आर यू
दीजिए, अगर मुस्लिम्स कोर्ट के पास जा रहे हैं वो मॉस्क वापस ले ले, क्या आप उनके साथ खड़े कि नहीं? हिम्मत है तो बोलिए।
You are not following the law. We are not following the law. Why? What is?
I want to ask you, Tehseen Poonawala, you know, when Mr. Ambedkar says that he is following the law and he holds up, the judgment of the Supreme Court, I want to ask you, today's judgment, is that not part of the law? Are we to interpret it, or has the district judge given his verdict? If it is not acceptable to certain people, they can go to a higher court. That is the way the constitution works. Why are we beginning to find fault with the verdict that has come, and why are we holding up the 1991 Act when the judgment today says the matter can go on? And the fact is, when you invoke the 1991 Act and the cutoff date of 15th of August 1947, my friend, after the 91 Act, Gauri, Shringar, Puja was being offered there till 1993. Why don't you remember that? Where is the amnesia in remembering that?
No amnesia. So let's answer three specific questions you raised. Adding to what Anand said. Anand, like you, I am a fellow atheist, perhaps in a minority in this country. So Anand, hypothetically speaking, if a Muslim side went to the Supreme Court saying, look, we had a mosque here that was demolished by a Hindu or any other king, I would say that is wrong, because the Places of Worship Act is sacrosanct. The 1991 Act is sacrosanct. To the second point,
then if it is sacrosanct, why is the Supreme Court? Why is the Supreme Court hearing the matter? It should have thrown out the matter. Why is the Supreme Court hearing the matter? No, Dr. Anand Ranganathan. Dr. Anand Ranganathan, if the Supreme Court is hearing the challenge on the 1991 Worship Act, it's not as if it has not admitted the matter. It's not as if it is not hearing the matter. Now, if it is hearing the matter and the next hearing is on the 11th of October, can we already say that questions have not been raised and the Supreme Court is not...
But in a democracy, you can raise questions. It's a part of the basics of
So exactly my point.
BJP raises on secularism.
So exactly my point. The petitioners in Varanasi have exactly done the same thing.
So, and
they've gone with...
Who stopped their legal right? Who on this panel said it's not their
Anand
legal right?
Anand Ranganathan, chit bhi meri, pat bhi meri.
It's like BJP. We are friends with Israel, but we glorify Hitler. It's exactly like that.
No, 1 minute. Hold
now, Tehseen, as a fellow atheist.
Sure, Anand, please.
As a fellow atheist, anyway, there are 13 countries that prescribe death sentence for us. So please, we should stick together.
I hope we don't
Point
have
number one, Navika.
Okay, all right.
Navika, let me expose the hypocrisy of my good friend Tehseen, who's like must be a brilliant sailor because he's tied up himself in knots. Number one, he is saying the Supreme Court, as you correctly said, that is hearing the matter of Place of Worship Act, but Parliament is sacrosanct. Will he now say on record that the overturning of the Shah Bano judgment was sacrosanct and Supreme Court judgment on Shah Bano should be rubbish? If you have the guts, say Parliament was sacrosanct then. Say it.
No, I think that I think the Supreme Court is the right thing in Shah Bano. Anand, the difference between you and me is I take a position based on the Constitution. I think the Shah Bano decision by the Supreme Court was right. I think the Congress government was wrong in overturning it. That's where I stand. I stand by the principles of our Constitution, not by organs of our Constitution, the Parliament or the court. That's the difference between you and me. I stand by my Constitution, and the Shah Bano judgment by the Supreme Court was right. The Congress government was wrong. When it is wrong, it is wrong. I am saying this.
So was
I stand by the
But
Constitution.
the Congress has righted it. And Vinod Bansalji, I just want to ask you. Today, if somebody were to raise the question about the 1991 Act, which is being heard by the Supreme Court, To my mind, the Supreme Court is hearing the matter, so the last word has not been said on that entire issue. The Supreme Court will give its last verdict, and we'll all, as citizens of this country, take whatever the Supreme Court says. That's the law of the land then. But the question is, the 1991 Act, when several people have said that this was a law that was put in there in a manner to give some sense of appeasement, and questions were raised in Parliament at that time. The BJP had walked out of Parliament. Today this matter, BJP has not put it in the dustbin. Today the matter is back in the Supreme Court because people want to challenge it. Now that challenge is something that is being questioned. But the challenge of the CAA law by our friend here, that should not be questioned. Why is there this hypocrisy? Why are there these double standards?
Thank you very much, Navika ji, for allowing me to speak after 30 minutes of the debate. I would like to convey all my fellow panelists. No issue. But I just want to convey my fellow panelists that the position of the 1991 POW Act is all decided by the Supreme Court. And this matter is still under discussion under the Honorable Supreme Court hearing. And second thing is that as far as this particular case is concerned, this matter has gone to the High Court as well as to the Supreme Court, where the Honorable Supreme Court clearly says that the hearing of this petition never attract any provisions or violate any provisions of the 1991 this Act. Second thing is that I would like to say something to your viewers. It's very surprising. This is the only country in the world where the majority community is being suffered by the atrocities committed by the so-called minority community, and persistently being attacked by those Muslim invaders. That time by the Muslim invaders, now by the so-called minority community of the country. आप बताइए कि देवादिदेव महादेव जो हिंदू समाज के लिए सर्वाधिक पूजनीय जो है वो अपने भगवान हैं, वो भगवान स्वयं जाकर के कोर्ट के अंदर लड़ रहे हैं और उनको शर्म नहीं आ रही। कमाल की बात है। और उसको जिसको हम महादेव कह रहे हैं, हम उसको पूजा का अधिकार मांग रहे हैं, हमने कोई जमीन का अधिकार नहीं मांगा नाविका जी, हमने कोई कब्जा नहीं मांगा। भारत का हिंदू समाज कोई कब्जे में विश्वास नहीं करता, सामंतवादी सोच नहीं है हमारी कि किसी के गर्दन काट दो और उसका जमीन सारी हड़प लो। लेकिन हम तो चाहते हैं हमारे भगवान की पूजा करने का तो अधिकार हमें मिलना चाहिए ना जी। हम अगर आपको को मक्का मदीना छीन रहे हो तो बात समझ में आती है। आप मुझे बताइए, अगर मैं लीगल बैटल लड़ करके मतलब सदियों पुरानी जो हमारे ऊपर एट्रोसिटीज है उनको मैं ठीक करना चाहता हूँ।
सऊदी अरेबिया क्यों इतना प्यारा है?
अरे हाँ, बिल आ गए ना, मैं वही कह रहा हूँ।
नहीं साहब, नहीं,
मक्का मदीना का नाम लेते के साथ बिल आ गए। मैं कहता हूँ मक्का मदीना से ज्यादा मेरे लिए पूजनीय है।
मक्का मदीना थोड़ी
मक्का मदीना से भारत की बात मेरा देवादिदेव महादेव की गौरी श्रृंगार पूजा की बात कर रहे हैं। ये बीच में आप मुझे बताइए, मुझे मक्का नहीं चाहिए, हमें मक्का नहीं चाहिए, हमें वेटिकन नहीं चाहिए, हम तो भगवान भोलेनाथ की वो पुण्य भूमि चाहिए और हमें तो पूजा की अनुमति चाहिए। हमें कोई कब्जा नहीं चाहिए आपकी तरह।
उत्तर प्रदेश
आप कब्जे में विश्वास करते हैं, आप लोग सामंतवादी सोच के व्यक्ति हैं, आप गला काटने में विश्वास करते हैं, इस्लाम के नाम पर गला काट प्रचंड चला रहे हैं, उस पर नहीं बोलेंगे आप। पूजा का अधिकार है, हम कह रहे हैं कि हम सिर्फ पूजा करना चाहते हैं, भगवान की पूजा करना चाहते हैं, और आप कहते हैं उसी भगवान के ऊपर आप वजू करना चाहते हैं। आपको शर्म आनी चाहिए यार। जहां पर हम पूजा करने की बात कर रहे हैं, सृष्टि के कल्याण की बात कर रहे हैं, लोगों के सुख की कामना कर सर्ववंतु सुखने सर्वे संतु निरामया की बात करते हैं, आप वहां पर वजू करना चाहते हो, आप वहां पर थूकना चाहते हो। शर्म आनी चाहिए, शर्म आनी चाहिए। कम से कम पहले कांग्रेस के प्रवक्ता थे और आप पैनलिस्ट होकर के अपना भेष बदल के आ रहे हैं। मैं कहता हूं बिल्कुल नहीं होगा। मैं कहता हूं पूजा करने का अधिकार मिलना चाहिए हमें, और जब पूजा का अधिकार की बात हो रही है
अभी हम वहां पहुंचे नहीं है। आई वांट टू कम इन हियर। अभी ये मुद्दा है ही नहीं, अभी ये मुद्दा है नहीं कि ये वजू खाना है, वेदर दिस इज अ फाउंटेन और व्हाटएवर इट इज, That part of the hearing has not even begun as of now. My only issue is, and I take this point of Vinod Bansal ji to Atiqur Rehman. Atiqur Rehman, Mr. Vinod Bansal is saying ours is a reasonable request. The reasonable request is that give us the right to pray, because we were praying there till 1993. Give us that right to pray back to us. We do not want ownership of the land. Is that a demand, or is that something that they are asking for too much, that they should not be, they should be criticized for going to court for it?
No, not at all, Navika ji. I congratulate Vinod Bansal ji to get awakened, coming out of a deep slumber. My only issue is, सुन लीजिए विनोद बंसल जी, 1991 से अब तक के कहां सो रहे थे, कौन सा नशा करके पड़े थे आपने अयोध्या मैटर के साथ इसको क्लब क्यों नहीं किया?
वहीं थे
आपने ये सब धमाल करने से पहले,
और वहीं रहेंगे। हम तब भी पूजा करते थे, हमारी आस्था उस समय भी थी और आज भी है, उसको रोक नहीं सकते आप। लेकिन ये कि पूजा के अधिकार पर आप कुठाराघात क्यों करना चाहते हो? हमने आपको हजारों लाखों मस्जिदें दे दी, भारत के अंदर आपको मस्जिद बना के दी है, लेकिन उसके बावजूद भी आप
लड़ाना क्यों चाहते हो?
पूजा करने का अधिकार नहीं।
अच्छा, अभी आपके पास
कितने परेशानी हो रही है?
कितने मंदिरों की लिस्ट है?
गलाकार प्रतियोगिता चला रही है, तलवार लेकर के आप बताइए, खंजर चलाने के लिए प्रधानमंत्री की गर्दन को पकड़ते हो।
इसीलिए मैं पूछ रहा हूँ, ये गला काटने की प्रतियोगिता खत्म करते हैं।
प्रतियोगियों के साथ समझ,
अरे इस प्रतियोगिता को खत्म करने के लिए आप पूजा की बात कर रहे हैं, कितने मंदिरों की लिस्ट है?
Atiqur Rehman, your question is आप कितने और मांगोगे? I mean, who knows? Who's an astrologer? Who is a Jyotishi here, sitting and looking at the future? Today the issue is about Gauri Shingar right to pray, and that is the matter under discussion. I want to ask you, why is it going on this track कि आज आपने ये मांगा, कल आप और मांगोगे, आज ये हुआ है, कल ये बाबरी मस्जिद की तरह हो जाएगा? Anand Ranganathan, I have a problem with that line of thinking, that line of questioning, because that is where this destabilization argument of Asaduddin Owaisi comes in. And that is where the question is, should destabilization only happen because Hindus are asking for something? Does it not happen otherwise? That's the legitimate question.
Absolutely, but before, with due respect, I object to the words used by Mr. Atiqur Rehman.
Also establish the fact where I lied.
I will.
Where I lied, sir. Yes. The Supreme Court said in the Ayodhya judgment that
Navika, you are
allowed.
Okay, Atiqur Rehman. Anand Ranganathan is responding to both your points. Yes, Anand.
Yes. Now, Navika, first of all, I object to the language used by Mr. Atiqur Rehman against the VHP person, saying कि आप कौन सा नशा कर रहे थे. This kind of derogatory language is exactly the kind of dog whistling that must be avoided. How dare he say कोई हिंदू नशा कर रहा था? अगर उसने, and let me tell him, अगर इन्होंने पढ़ा नहीं है तो ये पढ़ लें. The historian Sri Sitaram Goyal has meticulously tabulated 1862 mosques that are built upon demolished temples. 1862, and according to J. Sai Deepak and Dr. Swami, this number could be as high as 40,000. And that is why we need to look for each and every shivling, wherever it is, hidden or exposed, underground or over it. We owe it to our ancestors, Navika. We owe it to justice itself. भाड़ में जाए वो लोग जो कह रहे हैं कि आप ये लाएंगे देश में वो आएगा. जस्टिस के लिए लड़ रहे हैं तो चाहे 40,000 के लिए लड़ना पड़े, लेकिन लड़ेंगे क्योंकि जस्टिस के लिए लड़ रहे हैं.
When he says लड़ना पड़ेगा, Mr. Ambedkar, he is not saying that लड़ना पड़ेगा means fighting on the streets. That is what is being alluded to. The fact is he is talking about fighting in the courts. And if it is fought in the courts, what is your objection, Ambedkar ji? Should people, if they have an issue, if they want a claim to be settled, can they not go to the court? What's wrong with that?
Mr. Anand गलती से बहुत सारी realities को बोल दी है. This is the reality that he is targeting 1862 mosques Not only 1862, then 40,000 mosques. This is the apprehension. That's why we are talking about. This order is turbulating Mr. Anand. That's why I'm telling. बहुत परेशान है इस ऑर्डर के वजह से।
मैं परेशान हूं क्योंकि जस्टिस के लिए आप लॉयर होके भी परेशान नहीं है, क्योंकि आपका एजेंडा है, आपका एंटी हिंदू एजेंडा है।
You are not respecting the constitution of India.
ऐसे कैसे चलेगा नाविका? मुझसे इतनी दुश्मनी क्यों नाविका? मैंने पंजाबियों का क्या बिगाड़ा है?
भाई मुझे नहीं पता. I am neither an astrologer, nor a doctor, nor a psychiatrist, nor a lawyer. So why दुश्मनी क्यों है ये मैं नहीं बता सकती. नाम मैं इन 4 कैटेगरीज में कहीं भी नहीं हूं.
अतीकुर रहमान को रिबट करना है. आपने मुझे 2 मिनट कहा था देंगी.
All right. Yeah. Go ahead.
Thank you. And I cannot let that lie go unpunished, because he was simply lying. Now let me give you the facts. Let me quote from the SC Ayodhya judgment. The SC accepted the fact that I'm quoting. Number 1, the Babri mosque was not constructed on vacant land. 2, the excavation indicated the presence of an underlying structure below the disputed structure. 3, the underlying structure
demolished to build a mosque.
नाविका मैं नहीं बोल रहा.
Temple was demolished to build a mosque.
झूठ बोल के.
No, temple was demolished.
All right, Atiqur Rehman, he is reading the other excerpts. You can rebut after that. You've already rebutted. Answer to that rebuttal as well, Anand Ranganathan. Respond to that as well.
Supreme Court of India, Ayodhya judgment, 2019.
आपको मजा
No temple was demolished to build a mosque.
All right. Anand Ranganathan is responding.
You are lying.
Anand Ranganathan is responding to what he says is your lie. Anand Ranganathan, respond. All other faders down.
Thank you. Mr. Ansari was right. डरा हुआ मुसलमान आपके सामने इतना डर के कांप रहे हैं. I am quoting the Supreme Court Ayodhya judgment. I have already quoted 2. Point number 3. The underlying structure was at least of equal, if not larger dimensions than the disputed structure. Number 4, the excavation of the walls of the underlying structure coupled with the presence of pillar base support, the conclusion of the ASI of the presence of a structure underlying the disputed structure. Number 5, archaeological finds in the area of excavation reveal significant traces of successive civilizations commencing with the age of the North Black polished ware traceable to the 2nd century BC. Number 6, on a preponderance of probabilities, the archaeological findings on the nature of the underlying structure indicate it to be of Hindu religious origin, dating to the 12th century AD. Number 7, the mosque in dispute was constructed upon the foundation of the pre-existing structure. Number 8, the layered excavation of the site of excavation has to be revealed the existence of a circular shrine together with Makara Pranala, indicative of Hindu worship dating back to the 8th or 10th century. कुरान में भी आपसे ज्यादा जानता हूं, सुप्रीम कोर्ट में भी आपसे ज्यादा जानता हूं. अरे आप जानते क्या हो अतीकुर रहमान साहब? क्लासेस देनी शुरू करूं आपको?
Atiqur Rehman, now respond. No, I have to give the right of rebuttal to Atiqur Rehman before I come to you. Yes, Atiqur Rehman.
So ये डरा हुआ एथीस्ट कहां से आ गया? कहां से डर पैदा हो गया? I am just saying that the Supreme Court opined no temple was demolished to build a mosque. The entire judgment you can read throughout the night. No temple was demolished.
Hindu religious origin is a mosque.
Atheists do not have the caliber to hear.
Navika, I can't go on like this. आपको मुबारक
हो Atiqur Rehman साहब. No temple was demolished to build a mosque.
Well, but there was a structure below it. That is what the Supreme Court said. Your belief and his belief can you know, one minute. Tehseen Poonawala.
I'm going to, Anand, unfortunately you're wrong here. While the Supreme Court did say that there was a 12th century structure here, the Supreme Court goes on to say the 12th century structures 400 years before the Mughal invasion, and there is no evidence to show that this structure had anything to do with the mosque. Therefore, the court goes on to specifically say that no, there is no evidence of a temple being demolished for this mosque. It goes on to say that the demolition of the mosque itself was illegal, and therefore the trial must go on. So, Anand, what happened in 12th century has nothing to do with the mosque. That, as so far the judgment is is concerned, is
Navika,
Vinod Bansal, 1 minute. Vinod Bansal, ये argument about the Ram Mandir will come in. The argument about the fact that you are, wanting to reopen 40,000 other cases. The argument about that this is a title suit. All of these arguments are now coming in, and of course, the Places of Worship Act of 1991. I just want to ask you, Mr. Vinod Bansal, why are these arguments, which prima facie would have been looked at by the Supreme Court when the Supreme Court allowed this matter to go on and ask the district judge to pronounce the judgment on whether or not the hearing can go on? Why are these issues being raised yet again when these arguments have not found merit in the district courts?
Definitely, Navika ji, I'm also very surprised to note the debate which is being held in this national channel, and the person who doesn't have the logic behind the particular case are going to go hither and thither. आप मुझे बताइए, आखिरकार जब बात काशी विश्वनाथ की हो रही है तो आखिरकार अयोध्या में क्यों पहुंच गए? भाई, अयोध्या का वर्डिक्ट तो आ चुका, वो तो कोर्ट डिसाइड कर चुका, यूनानिमस डिसीजन है, माननीय सर्वोच्च न्यायालय का है, सर्वसम्मति से निर्णय लिया गया है, उसमें आप कुछ भी कर लो, एड़ी चोटी का दम लगा लो, वो कुछ नहीं हो सकता। अब तो उन्होंने, माननीय चंपत जी ने अभी घोषणा कर दी है कि अगले मकर संक्रांति तक जो है ना उसका आप दर्शन कर पाएंगे। मैं सारे पैनलिस्ट को इनवाइट करता हूं, आराम से शांति के साथ जाएं, भगवान के दर्शन करें और अपने पापों का प्रायश्चित करें। नंबर 1, नंबर 2 आप दूंगा, 1 मिनट
बोल ले विनोद जी, बस 10 सेकंड। हाँ, नाविका आपसे हाथ जोड़ की विनती है, क्योंकि बिना हाथ जोड़े आप मानती नहीं मेरी बात, पता नहीं क्यों। नाविका, हाथ जोड़ की विनती है, प्लीज गो अराउंड द पैनलिस्ट एंड आस्क देम अ सिंपल क्वेश्चन। डिड औरंगजेब डिमोलिश द काशी विश्वनाथ टेंपल, yes or no? I say yes. Vinod ji,
was India democracy then, a constitutional democracy then?
Vinod ji,
answer the question.
India was a constitutional democracy then?
आप क्वेश्चन पेपर से बाहर क्यों पूछ रहे? पहले क्वेश्चन का जवाब तो
मैं क्वेश्चन का जवाब दूसरे क्वेश्चन
yes or no?
भारत उस वक्त संवैधानिक मुल्क था, क्या भारत उस वक्त संवैधानिक मुल्क था?
First question he believes
constitutional democracy.
Ambedkar ji, did Aurangzeb demolish the structure in Kashi Vishwanath on which the mosque came up?
Akbar built it.
Yes or no?
सेम क्वेश्चन रेज होता है कि पुरी के जगन्नाथ मंदिर,
ये देखिए, देख रही है,
वो कहां से आया?
ये है डर, इससे डर कहते हैं।
भैया, काशी विश्वनाथ की अभी तो काशी विश्वनाथ तक की आपकी टिकट है, आप क्यों जगन्नाथपुरी जा रहे हैं? क्यों जा रहे हैं? विष्णु जैन जी, there is only one question that Dr. Anand Ranganathan has raised, and that question is about whether Aurangzeb demolished the structure of a mandir in Gyanvapi, yes or no. On that, the matter just goes from one place to another, goes to Babri Masjid, goes to Ayodhya, the judgment of the Ayodhya verdict, where it was said, according to Atiqur Rehman, that there was no mandir on which the Babri Masjid was built, and then it has gone to Jagannath Puri. I want to ask you, why don't they answer this question straight on the face?
Because Navika, the fact of the matter is that they know that the Farman of Aurangzeb is a documentary evidence which is existing on record. It's present in the Asiatic Library of Calcutta, and we have also produced it on record, where Aurangzeb categorically said that go and demolish the temple in Vishwanath, and on a particular date it was reported to him that the temple at Vishwanath has been demolished. So they cannot argue this, that the temple has not been demolished. And Navika, let me tell you that in the case filed by them, Deen Mohammad's case, it has been held and it has been proved that the temple was demolished demolished and on the remains of a Hindu temple a mosque has been constructed. I don't have to prove that a temple has been demolished. In the constitutional challenge to the Kashi Vishwanath Act of 1983, the Honorable Supreme Court authored its judgment through Justice Honorable Mr. Justice Ramaswamy, who said in para 1 of that said judgment that a mosque has been that a temple has been demolished and a mosque has been constructed. And how many times temple has been demolished? All those history has been recorded in that judgment. And the fact of the matter is that all these facts Mr. Atiqur Rehman knows. Therefore, he will never argue on the facts of Kashi Vishwanath case. Whenever you will talk about Kashi Vishwanath case, he will talk about Ayodhya's case, because that's the merits of the matter, and we argue each and every case on its own merits professionally and very clinically.
Atiqur Rehman, you've been found out, you've been exposed by Vishnu Jain ji. You want to respond to him?
Yeah, of course. Navika ji, what a bigoted emperor did in the 15th and the 16th century, you are repeating the same bigotry in this 21st century in the presence of the Constitution of India. Aurangzeb never was guided by a constitution. He was a bigoted leader, an emperor.
Chalo, at least an admission that Aurangzeb was a bigot has come from Aurangzeb was a bigot, at least that much Atiqur Rehman has admitted today. Vishnu Jain, why are you doing today when there is a democracy, when there is a constitution? Vishnu Jain, that's the counter question.
People are repeating
Navika ji, please, Navika ji, I want to ask a question, that if you will keep doing wazoo over my shivling, what rights I have? How should I proceed further? Should I go to the parliament? Should I block these streets? The only democratic method which is available to me is to file a suit. And therefore I have filed a suit before the courts of law.
Vishnu bhai, with humility,
you are doing wazoo on my shivling. I am saying that on shivling wazoo cannot be done. And what Muslims had argued before the Supreme Court.
The question is that it was happening and that was causing problems to the faith of the Hindus. Now, you know, so that is stop. But that's only interim. That's only interim.
But if tomorrow they say it is a
injustice well, of course, if the court decides one way or another, they will stop demanding that. But as of now, the question that has been troubling the Hindu side has been the question of wazoo in the site where they believe that there is a shivling or the stone structure that has been found in the survey that was carried out. Today, the question is not about destabilization of the nation. The question is really about finding a redressal to the questions that the Hindu side have in a court of law. How can anybody have objections to that when the law is being invoked and when the judiciary is taking the call? Can that also be a problem in a democracy and in a country that is run by the Constitution? It's a question that Mr. Owaisi should ask himself. Well, let's leave it at that on this big day when the Gyanvapi verdict at least says that the rights now will be heard further by the district court. Will this be challenged in the court? Most certainly. We'll wait and we'll keep you ahead on what happens from here on in the higher courts of the country. Thank you very much to my panelists and thank you, dear viewers, for joining me on the Newshour tonight. Good night. Be safe.